Welcome to the immigration team at DMH Stallard's webinar today. A lot of you will be joining. We've got a very large number of attendees, which is great to see. So a lot of you will be joining while I'm speaking now. So I will just give a brief introduction to the session today while people are joining us. But firstly, talking about the speakers, I'm Adam Williams. I'm a partner in the immigration team at DMH Stallard. And alongside me today is Philip Vallen, Senior Associate in the team, and we'll be guiding you through the issues to be thinking about on the question of whether you're ready for 2021 as an organisation, obviously in the specific context of employing foreign or migrant workers in a post-Brexit world. And why are we having this session today? Why am I talking to you this morning? And why is Philip going through the changes with me? Well, it's because we're now less than 5 months away from the end of the Brexit transition period. And as it stands today, there are no indications from the government that there's going to be any extension to that transition period, for example, because more time is needed to finalise a trade agreement. There are no indications of that as of now. So our only assumption can be, based on that, and a sensible assumption, as an organisation that employs EU nationals or foreign workers, is that from New Year's Eve, the transition period will end, and along with it, so will free movement. And that's going to have some massive changes for certainly particular types of employers, but pretty much every employer in the UK will feel the effects of that in one way or another, in terms of what it does to the ability to employ Europeans in a frictionless way in terms of borders and immigration and visas. So we're going to start by asking you some poll questions. Just check you're all there and get a sense of your situation, really, the context for this session today. So the first poll, if you don't mind participating in this, is to ask you whether you currently employ EU or EEA nationals. So we'll just wait a second for people to do that. You should now see the poll on your screen. You can vote yes or no. We're just waiting for the results to come through. Okay. Not surprising the outcome, but overwhelming in the actual amounts. We've got just under 90% of you currently employing EU or EEA nationals, and 11% said no. So for anybody who's just arriving or you had difficulties during that first poll, I'm sure that it wouldn't have massively changed the outcome, which is overwhelming majority of people currently employ EU or EEA nationals. So 89% of attendees today do currently employ EU or EEA nationals, and a tiny proportion do not. On to the next poll. Do you anticipate employing people from outside the UK, not just Europe, but outside of the UK generally, after New Year's Eve, so 31st December of this year? So this one is forward-looking, another yes, no. And again, don't worry if you are able to put your answer in but can't see the outcome. I'll be obviously delivering that verbally as well. So do you anticipate employing people from outside the UK after 31st December 2020? We just went the result. And almost the same level, not quite as high, but 86%, down from 89 who currently do, saying they do anticipate that. So very little drop off. Again, that's broadly consistent with what Philip and I are seeing when we're talking to our clients and with our expectation. Only 14% of attendees aren't anticipating doing that. Next poll. Are you currently a licensed sponsor under Tier 2 of the points-based system? Space there for you to put yes or no. And a couple of people putting their yeses to me on the chat function. That's great. Thank you for that. We'll see whether the numbers are close, in which case that may inform the outcome. And just a housekeeping point, I should have mentioned that if you have questions that you want to put to the panel, please use the Q&A function at the bottom of your screen. If you have a technical issue, that's the chat function. So any issues with accessing the system, it's the chat function, and the Q&A is the normal Q&A function. Right, so it is relatively close. It's 55% of you saying you're not currently a licensed sponsor, and 45 that you are. So fairly even split there, and we'll take that into consideration as we go through the session today. The good news is that this session is relevant to both existing sponsors and to those who aren't yet a sponsor and are thinking about how, when, or if they might need to be. Now on your screen now, you'll see a broad agenda for today. We haven't got a long time. It feels like a long time having a roughly an hour window, but there's a lot of ground to cover that we won't be able to touch on in that time today. But in the first session that I'm going to hand over to Philip on shortly, we'll be looking at the end of free movement for employers more generally. What is actually changing on New Year's Eve? An update on the EU settlement scheme. What does that mean? How does it influence right to work checks? And also we'll look at the issue or the impact of the end of free movement on working in the EU if you're a British national. After that, we're going to move to a session that I will do on the new, I've put in inverted commas for reasons I'll come on to later, points-based immigration system. Who will it apply to? What will the key changes be? And points for you to note if you're already a sponsor or you're thinking about becoming a sponsor between now and the end of the year. How does it actually work? Some comments about cost-benefit analysis now that friction is in place, or will be in place, sorry, from 2021 for EU hires. There's going to be some interesting analysis to be done there and strategic decision making internally, I'm sure, and some action points of things that you may need to be thinking about doing from here on out in this slightly less than 5 months time that we have left. So I'm now going to hand over to Philip, who's going to pick up the first of our 2 broad sessions on the end of free movement. Over to you, Philip.
Thanks very much, Adam. Good morning, everybody. So yes, I'm going to be talking about the end of free movement, looking at what we currently have in terms of access to the UK employment market, how the EU settlement scheme currently works, how right to work checks are being affected as we move forward, and also what's changing for UK nationals. So in terms of the current position, it's worth just recapping on where we currently are. You can see that there are 3 main routes for individuals to come to the UK and have permission to work. Currently, EEA, EU nationals have free movement rights. They don't require a visa. They can come here to the UK and look for work. They don't have to have a job immediately. There's no minimum skill level, but this is now time limited due to the transitional arrangements. And then on the other side, we have the points-based system for non-EEA nationals. Visas are required. Employers have to be licensed sponsors, have to conduct the resident labour market test, and individuals can only come to the UK when they are being employed in a role that meets the minimum skill level and has the necessary salary. And the other route is Commonwealth ancestry or being a family member of a British citizen, but we won't be touching on that today. Looking then at the EU settlement scheme. So currently, EU workers continue to exercise their free movement rights, and they can do that up to 11 p.m. on the 31st of December 2020. Those who are here already or will come in the next few months are able to apply for settled or pre-settled status. And in fact, the deadline for that will run past the end of December, and they'll have until the 30th of June 2021 to make those applications. Those who've been here for 5 years already can get settled status, and that means they have a permanent residence, which will only be lost if they have an absence of exceeding 5 years from the UK. And those who haven't been here for 5 years and those who are coming subsequently to today should be able to get pre-settled status as long as they're here exercising their rights before the 31st of December, and that will be a residence for up to another 5-year stay, at which stage they'd be able to apply for settled status. Looking then at the right to work checks on the next slide, we've got, what's changing for EU nationals in terms of the end of free movement. So EU nationals will no longer have the right to come to the UK to look for work or to study, and they will have to be within the sponsorship system in that respect. In terms of visitor rights, the expectation is that all of the EU will be put onto the non-visa national list, and they'll be able to come to the UK as visitors without requiring permission, make use of the business visitor visa regime. They'll have their right to work, right to remain, right to study will all be governed by the sponsorship, the points-based system for those who want to come for work. However, it's anticipated that EU workers will be able to avoid biometric enrolment. They'll simply be able to provide a digital image of their face, which will be used to produce their documentation. Looking then at the right to work, and so we now have a system of electronic checking in place, and the government has also made clear that EU workers will get a physical document, so there'll be something like a biometric residence permit for everybody. We're not going to be moving to an entirely digital system, which hopefully avoids any potential problems with people with the digital system not working. As you may know, the right to work check system has been relaxed considerably due to the COVID-19 outbreak, and so checks can now be completed at arm's length over video, with individuals sending their documents scanned to email or via an app, and the employer able to conduct right to work checks and gain the protection from a civil penalty via that method. For EU workers, there's the right to work checking system, and also for those who hold biometric residence permits, they can now obtain this share code, give it to the prospective employer, who can access the online system via that view right to work link shown on the slide, and obtain confirmation that individual has the right to work in the UK. It does seem as though the plan is to move much more towards a system of electronic checks. So hopefully from that perspective, the system will be a lot more efficient for employers. Then finally, looking at working in the EU for British nationals, we are going to be faced with 27 or more different business immigration regimes, certainly immediately, the EU 27 plus the economic area countries and Switzerland. There are unique arrangements with Ireland, so British nationals and Irish nationals can move freely between Ireland and the UK without the need for work permits or anything like that. The only real barrier there is recognition of qualifications, but that is one area where effectively a system very similar to free movement will continue to exist. But otherwise, UK individuals are going to find they have very limited visit rights across the EU 27. It's going to be much harder for an individual who regularly works in Europe to simply go and do their job. They're going to have to ensure that they have the correct permissions. And those of you who know the UK business visitor regime may also know that the European countries tend to have less attractive rules, and it's much harder to do anything without a specific permission. On top of that, each country will be able to potentially make its own arrangements in terms of recognition of qualifications. So rather than the position we have now, where there's mutual recognition of qualifications, each country will be able to say, well, we don't accept that. You need to undergo a process to have your qualification recognised here. So movement for UK workers into the EU will become very much harder post December 2020. I think now I'll hand back to Adam, who will discuss the new points-based system which will be coming in.
Thanks, Phil. I might just keep you on the screen there for a second, if you don't mind, Phil, just on that last point you picked up. I think it's quite an interesting one for for people watching today on moving British nationals in and around the EU, there's that issue there you mentioned about the 27 states. And what we find, I think, your experience like me, is that looking ahead, it effectively becomes a very varying and different picture depending on the country of destination. And it's probably worth touching on sort of some of the options that end up being explored, but probably don't quite fit the bill for certainly someone who wants to do proper productive work, like the blue card scheme. And our experience is that, or our expectation is that for businesses wanting to move British nationals in or around Europe to work, probably they're going to need to look fairly early at the different countries, aren't they, and the different regimes.
Yes, absolutely. I mean, there is this blue card scheme, which several member states have signed up to. And it means that if you have a job offer within one state, you can potentially get something akin to free movement across a number of states within the EU. But it does require to say that job offer already, and it's limited to the member states who signed up, which I think is currently 13 states. So in a sense, you're almost bound to find that the state that you want to move into doesn't have the blue card scheme, and you're therefore not able to actually exercise anything like a free movement right. You're left facing that similar problem of simply not being able to work in that state, because they won't accept that you've got a job within the UK. That's not enough. You need to be able to show that you've got a new job starting in that member state.
Yeah, indeed, and that requires you to have an employment with that corporate entity in the member state in most of those scenarios, doesn't it? Which means if you're looking at this as organisations, you may well be thinking it's actually about trying to find a way to, as seamlessly as we can, allow business visits, which, as Phil said, that requires you to look quite closely at what is or isn't permitted as a visitor. It is massively varied, and the UK, which is contrary to most of our position on most things, where we're seen to be the most hostile or narrow in our own interpretation, is actually one of the more generous, if not the most generous, countries in Europe in terms of what it allows visitors to do in terms of business. So ironically or unusually, you might find actually that compared to what your visitors to your business can do when they're here in the UK, there's actually a greater level of restriction on what they can do going abroad. So hopefully over time, of course, if you have common destinations you're sending British workers, you'll get that sense of and be able to remember and much more easily identify what they can and can't do. But another point to put in your action points there that comes out of Phil's last slide there about thinking about that movement, not just people coming into the UK, but movements into Europe. Where are those going to be, and actually do you need them to work, or is the business visit rules there sufficiently broad to cover what you need? And we help facilitate the advice on that. Of course, we don't give the advice for every different country. It requires some local support for certainly cases that are not just entirely straightforward. But that's something to start thinking about, I think. So thanks very much, Phil.
Thanks, Adam.
So now we're going on to what we've called there the new points-based immigration system. And although I've put it there as new, the reason that's in inverted commas is because for the roughly half of you that are already licensed sponsors, you'll find that it doesn't feel that new, certainly in its broad structure and framework. There are some significant changes coming, but the functioning of the system and how sponsorship works is not changing fundamentally going forward. So I put there on the slide that it's evolution, not revolution in that sense. What is changing, one of the obvious and most broad-reaching material changes, is the level playing field. And that by that we mean that it's long been stated by the Home Office and the government that its intention post-Brexit was to create this level playing field, a single set of rules and system that will apply equally to European nationals as it would to non-European nationals. And there's obvious reasons why they want to do that, unless there's a trade deal or other arrangement that justifies giving preferential treatment. Their starting point is that we we have an open and level playing field for the rest of the world. Now, what that means, though, of course, in terms of changes, is a huge change for EU nationals, EEA nationals, where currently there is pretty much frictionless movement, ability to move freely, to study, work, even just look for work through Europe, and that includes in and out of the UK. And that will be, that tap, if we can put it that way, will simply be turned off. So a massive change in relation to the European position, much less of a change in terms of the overall picture for non-Europeans, but some significant updates to the framework which will apply to them as well as European nationals. What does that really mean, that levelling up? Well, I mean, we looked at our poll, didn't we, at the start? A lot of you currently employ, well, in fact, the vast majority of you currently employ EU or EEA nationals, and indeed almost the same majority, up in the 80%, expect to continue to want to do so beyond New Year's Eve, when the transition period ends and free movement comes to an end with it, unless that transition is extended. It means that to have demand-driven access to foreign talent and skills will require a very different approach, particularly where you've been able to get that demand-driven access from the European labour market, where you haven't really had to do much at all in terms of work visas. And just to be clear, what we mean by demand-driven access is you need to have the ability to pull, i.e. go out and advertise for roles and pull talent from a wider international pool, or you want to get the very best person for the job, rather than supply-driven access. And this is terminology used by the Migration Advisory Committee that advises the government. Supply-driven access being, we've advertised a role either locally or more broadly, but we happen to have found that there's someone who wants to join us and has the right to work in the UK. Either they're already here on a partner, spouse visa, or they have some other much less common individual right to work. So we happen to be able to benefit from them. There's less control over that. It's based on luck and happenstance. If you want to have that demand-driven access, what you'll see today is that whereas previously you could draw on the European pool of talent on a demand basis without much extra visa requirements, you'll now have to enter into a framework of approved status and sponsorship for any foreign hire going forward. And there's going to be, I think, a need for businesses to look at the requirements that go with that, the extra work, compliance, oversight, etc., against the ability to upskill and or exploit the resident labour market. And that's going to come into this cost-benefit analysis that I mentioned earlier that we'll come on to later. And then you offset those factors against the additional cost and compliance requirements for being a sponsor to form this view of if, how and when we as an organisation need or want to have demand-driven access to foreign skill, migrant labour and talent. So moving forward to the next slide. What's the position then, the key position comparing this year to next? As Phil mentioned, the key point in time here we're talking about, or the shift, the gear change, is 11 o'clock on New Year's Eve. The key points are largely there's a whole group of changes which is really just about terminology. I did an article recently and a radio interview about the rebranding, which sounds slightly cynical, I suppose, but there is essentially just a rejigging of terminology. So what anybody who's currently a sponsor is familiar with in terms of Tier 2 General as a visa description or category, that will become the skilled worker route. The further details document released by the Home Office in July talked about route. I suspect it will also become known as the skilled worker visa. And you can see there's some more sort of plain English change there, broadly positive thing, to just have the new name of skilled worker route. There will still be the current other work visa type of intra-company transfer, and that name is not changing. It's important to know that's still there, and we'll touch on how important that might be, the intra-company transfer route, or what it is and why it might still be important or become more important, depending on what other changes might happen to the skilled worker route in time. And we're going, it seems, from a terminology of being licensed to bring in and sponsor workers from abroad to being an approved sponsor. I think, again, that's just something that's kind of plain English, putting some more flexibility into the language. And of course, it's indicative of the reality, which is the Home Office grants the license or approval, and they can remove that approval. They can decide that they will not approve you anymore and either downgrade or suspend your license or revoke it. A key point in terms of changes between now and New Year's Eve is that we've been told existing license sponsors will automatically be given approved status. Others are going to have to apply, of course, if they're not actually licensed at all. And the Home Office is encouraging prospective approved sponsor applicants to look at doing that now. We've got less than 5 months. It takes several weeks for an application to be just processed once it's been submitted. So I think they're particularly looking at those who feel they might, in the early part, certainly those who are thinking about the early part of 2021 and wanting people to come over and work from then, needing to apply now. The existing, for those of you, almost half of you that are already currently licensed sponsors, the indication from the further details is you'll get your approved status. We don't know yet exactly how, when that's going to be communicated, but that status will still only run for whatever's left of the 4-year current lifespan of your license. And the indication is that approved status will continue in the same basis. It'll be renewable on 4-yearly increments. There's a new solvency requirement. So anybody applying, or we think also renewing their license, will have an additional assessment done by the Home Office around solvency, which of course is just worth bearing in mind. Hopefully not an issue unless your business is under financial pressure or strain. Another important change is the skills drop. So we've had a lot of the language around the new points-based system from 2021 has been about, we want a highly skilled, the brightest and best. And that's what we're focused on for our immigration system for work going forwards. In actual fact, the skills level is dropping for the skilled worker route, currently Tier 2 General, from what is currently graduate level minimum requirement to A-level or equivalent requirement. And that's the role that has to be skilled to that level, not the individual. The actual requirement is for the role to be at that level, although indirectly there's a requirement for the individual to be effectively suitably skilled and qualified, because under the genuineness requirements, a general test that the Home Office deploys, or UK Visas and Immigration deploy, you will clearly need to be able to show that the person you're sponsoring to come in and do this stated role does seem to have the skills and experience that's commensurate with it. Otherwise you might fall foul of the genuineness test and be seen to be using the system inappropriately. Another key change is the cap currently applies on Tier 2 General visas, so the skilled worker visa that is the most common for the current situation, which is non-Europeans being sponsored to come into the UK to be employed. There is a cap, an annual cap. It means that for essentially mostly new hires from outside the UK, so it wouldn't normally apply if you're sponsoring somebody who's in the UK already and switching, for example, from a Tier 4 student visa to a work visa. But for new hires, you have to apply from a monthly limited allocation of it's effectively unique reference numbers, but what are called certificates of sponsorship, around 1,500 each month. And there have been months when demand has outstripped supply, so people have had to wait and try the next month to get a certificate. That is being suspended for the skilled worker visa going forward, which is important because in 2 ways. It means that there won't be a monthly limited allocation process and applications for that, and the risk that you might actually not have a high enough pay or shortage occupation, some of the requirements to get you priority for the number that are available for a month that you're applying in. But also in its terminology, suspended makes very clear that it isn't a complete removal and that there is a prospect in future of that suspension being removed and therefore the cap being reintroduced. That will be important in a way we'll come on to potentially in terms of the intra-company transfer visa, which is of different nature to skilled worker visa and essentially involves, when you apply for a sponsorship, you demonstrating that you have other entities elsewhere in the world who share common ownership or control with your UK entity and from whom you want to sponsor intra-group moves from that country to the UK. That is the intra-company transfer visa, and there tends to be a higher minimum pay threshold for that one. In light of this next change we're about to touch on, some of the key benefit of that visa route is falling away. But if suspension of the cap on the skilled worker visa route is removed later and the cap reapplies, the importance of it might come back. And I'll explain why now. Going forward, we'll have no resident labour market test. And I've put a hooray there because I'm sure that the roughly half of you are already licensed sponsors will be pleased to see that if you haven't already seen that bit of news. That's the stated intention. The resident labour market test is a requirement for certain types of visas, and in fact, the vast majority of visas where you're sponsoring a new hire for a skilled work role from outside the UK have to advertise for at least 28 days in 2 prescribed forums, you can pick from a number, and demonstrate that no suitable settled worker is available for the role. So either because no one applied, or because if they did, you were able to show they didn't meet a certain key requirement of the written job advert. It's a prescriptive process, it slows things down, and broadly speaking, I think the vast majority of employers will be happy to see that go. Now, the reason that made intra-company transfer a particularly important consideration was that already that test didn't apply if you, rather than getting a tier 2 general skilled worker visa, you were going to move someone within your group. You didn't have to do the labour market test. And that was one of the key reasons and attractiveness of that route. Of course, nobody will have to do the resident labour market test, whether it's a skilled worker visa or intra-company transfer visa going forward. So that attractiveness has fallen away. But if the cap on skilled workers is reintroduced, that will be a potentially important reason why intra-company transfer may become important again. If you find that the numbers, which could go up significantly here, of course, when everybody from outside the UK is put through this system, if they exceed the number of available certificates, that you might want the option to say, well, we can find a way to get the person in for a few years at least by using the intra-company transfer route for which there's no cap. So moving forward to some other key changes. Expanded switching. Now, switching is, for those who are existing licensed sponsors, you'll be familiar, is the name given to effectively a change in visa status from within the UK. So you would change, for example, from being a tier 4 student at university, and you might be doing a temporary role for an employer as an additional bit of work alongside your student visa, and you're applying to switch into a work visa because you finished your studies and you want to take on permanent employment with a sponsor. That's called switching. Now, at the moment, switching is fairly limited in terms of which visas are eligible for switching. That one I just gave you is the most common example. Examples that aren't eligible are things like Tier 5, the sort of short-term worker schemes, government authorised exchange, etc., where if we ignore the current COVID pandemic, which has created some short-term relief around this, you normally have to go back to country of origin and apply to return to take up a different visa. This statement of intent is expanded switching there so that presumably people who are here, for example, with an intra-company transfer visa that we just described, but who want to switch into a skilled worker visa, and they might do that because skilled worker can count towards settlement after 5 years, whereas intra-company can't. They may find that they benefit from the expanded switching of categories. We need to see the detail on that. There's going to be simplified rules and guidance. Haven't seen that yet, but we're in consultation, the team here alongside ILPA, which is the Immigration Law Practitioners Association, lobbying government alongside the Law Society around a drafting of the immigration rules to make them more straightforward and easy to understand, which will obviously be helpful, and simplified guidance, which again, we've not seen yet. Currently, the guidance, by the way, if you're an existing licensed sponsor or you're looking to become an approved sponsor, has been bolted on to what has always been the Tier 2 and Tier 5 guidance for licensed sponsors, where it talks about the changes in 2021 and thinking about applying now. So you have to look to that to have a sense of what the guidance actually requires of you. We expect those simplified guidance will be introduced in due course. We've been told that there are, and I'm not sure if this is a reference by the Home Office to what they're already mentioning they're going to do or further changes in future, but radical changes to the sponsorship process. In terms of what they've already announced, well, it seems to me that if there are radical changes, they're really limited to the fact that you won't need to do a resident labour market test anymore, and there will be a suspension of the cap on numbers. That would mean cutting down about 4 weeks of advertising and removing the monthly process of seeking to obtain a certificate from the limited number. You would just be able to ask for an allocation of certificates that you can then use. Aside from that, there isn't, I don't think, anything that I would view as a radical change to the process. And that indicates that there may be further changes to come. What the UKVI or Home Office have said at the moment is they will be looking to streamline the sponsorship process and make it more user-friendly. They'll be looking at apps, etc., other functionality, but they're not ready to do that yet. It's pretty clear that's a long way off. The sooner we get it, obviously, the better for employers who, certainly those who've not used this system before. There's a health and care visa, I think largely driven by the pandemic and the issues and concerns about the NHS, and that we should be ensuring that we have, not only do we recognise the benefit and the efforts and value of foreign migrants that are working in our NHS system, but we have the ability to attract and bring further people in on that in future. It's a visa essentially like the skilled worker visa, but with what we've been told will be a fast track processing time, reduced fees, dedicated support, and exemption or relief from the health surcharge that visa applicants normally have to pay to contribute towards the NHS. And the details of exactly how many people will benefit from that under the new A-level skill requirement remains to be seen. But given we're currently at graduate level, we've only seen an indication of who would qualify under the current graduate requirement, which is, as you'd imagine, quite narrow, only about, I think, 13, 14 roles within the health and care sector that would be seen as graduate level and benefiting. Tradable points, which we'll come on to shortly. We've had a points-based system, but most people agree that was in name only because it was somewhat binary. You got a certain number of points for different attributes, but if you didn't have any of those attributes and therefore got no points for them, you wouldn't be eligible for a visa. So you could have just done away with the idea of points and had a checklist saying, do you have these attributes? And if the answer is yes to all, you get a visa. If the answer is no to any of them, you don't. We're now going to have an element of genuine points-based trading, but only really around the issues of skill and pay. So not the fundamentals like, do you have an approved sponsor? Do you have a job offer? And do you have the skills? Are you suitable for a visa on the general grounds? So there's no adverse criminal records history, etc. It'll then be on the subsequent bits around the pay level for the role, your skills and education, where the tradable points come in. And I'll touch on that in a bit more detail in a moment. Intra-company transfer, or what we call ICT there on the slide, there's a higher pay requirement for that. So again, with the lack of resident labour market test and the suspension of the cap, I think often employers are going to look and say there isn't really much of an incentive to use intra-company transfer at the moment. In the short term, at least, when this new system comes in, it will depend on whether the suspension is removed, as I said. Unless, as the point I put here, there's an English language issue. Another distinction of intra-company transfer is there's no English language requirement minimum level, whereas on the skilled worker visa side, you'd need to be able to demonstrate a pretty good level of English language, which can be done, for example, by showing you've done a degree in an English-speaking country, or you take a test for it. So there might be a very small grouping of people where they work for your corporate group, they're working abroad, you want them in the UK, but actually, somewhat unusually, their English language is not great, where you'd say, well, the intra-company transfer route doesn't actually require them to prove a certain level of English language. Just on to the next slide. So how does it work? This is a recap for those who are licensed sponsors. For those who are thinking about being an approved sponsor, it's potentially new information. Well, to become an approved sponsor, that's either going to be automatic if you're an existing sponsor, and you'll get that automatically until, as I said, the 4-year lifespan of your current license is due to expire. Or if you're not yet a licensed sponsor, you've got to identify some key personnel to manage the license, ensure that they comply with the Home Office requirements of sponsors. And that requires, and we'll go into some detail about who those people are and some thought around that. You need to gather a selection of mandatory supporting documents, essentially go to this issue of the Home Office wanting to be satisfied you're a genuine employer, employing individuals in the UK in the manner that you say. Obviously, in very unusual and unfortunate examples, you do get people seeking sponsor licenses where they're not genuinely employed, they're just looking to traffic people or find a way to bring people in to the UK. So there's certain mandatory documents. They are tailored to the type of organisation that you are. So if you're a startup and you've had less than a certain period of trading, you'll have a certain selection of documents and supporting materials that you need to use. If you're in a sector where you're required to hold a registration for certain licensed activities, you may be required to prove that registration certificate. There are certain documents that you almost always have to provide, things like employer's liability insurance certificates. So it's important to bear in mind that, and that's a fairly early stage part of the process that we work on with organisations, because it can take time, once you've worked out what the documents are, to get together those certified or original copies. There is some suggested relaxation around needing to have originals or certified copies due to COVID, but the guidance isn't that clear. So our view tends to be that we should stick to certified copies of originals, or the originals themselves being sent in wherever possible. You then apply online, an online form, which you fill out, having registered for that system and got yourself access to the portal. You pay a fee to become a licensed or approved. It will be sponsored for 4 years. We'll come on to the cost of that shortly. And that will, after time, typically around 8 weeks, hopefully result in you being given your approved status. Now, then you need to identify, or you may have already identified, the migrant worker to whom you wish to offer a job, because they will need to have a job offer from you to be eligible to apply for their visa. Before doing that, typically you need to assess their suitability and the role's suitability. So in terms of them, do they need English language level of competency? If so, do they have it? And more importantly, can they demonstrate it? Do they have the skills and attributes commensurate with the role? Is there any other adverse immigration or criminal record history? It's a good idea to look at that if you can, because you don't really want to go through all the hoops of the process only to find that they were rejected for their visa at the end on general grounds, because there's some recent criminal offence or something that means they're not seen as appropriate for entry to the UK. In terms of the role, it's the skill level. What is the skill level for the role? What's the salary level? Because those things are going to need to meet certain minimum requirements for you to be able to successfully sponsor the applicant. If that all seems okay and you've identified your role and the person that seem to fit, you assign them a certificate of sponsorship, which is a unique reference number essentially, and that enables them to then apply for their work visa. They can't apply without it. And in assigning them that unique reference number, you are committing to the Home Office that you've done the background, you have got a genuine role, and that things are in order, and they will assume that unless or until they see otherwise, for example, on an audit visit later. So when you've assigned it, you need to choose the sponsor period, typically 3 to 5 years, depending on exactly how you want to do that, and set your intended start date, which can be moved through the sponsor note system later, but you need to have a clear date that you state on the certificate you're planning for them to arrive and start. You pay the applicable immigration skills charge. Again, I'll come on to the value of that shortly. And then the migrant applies for their visa. And they will do that. If you take an example of you're hiring someone from abroad, they'll do that from their home country. They'll apply online and they will potentially visit a visa application centre to give biometric information. Or if they're a European national, as Phil mentioned, it seems that they'll be able to do potentially an app and mobile phone photograph. Personnel and compliance then. We talked about preparing for becoming a sponsor. You need to identify the right people. Well, it's about your HR systems. One of the key requirements of being a licensed or approved sponsor is to have adequate systems in place to manage your license and meet your compliance requirements and sponsor duties. And you'll see at the bottom of the slide there, record keeping and reporting, some key duties there, alongside the obligation to comply with all applicable employment laws, not just those related to migrant workers and immigration, and including having the right to work checks in accordance with the Home Office guidance conducted across the board. Record keeping, there are specific additional records you must keep as a sponsor, additional to the ones you would normally have as an employer, and reporting. So certain key changes to your organisation as a sponsor or to migrant circumstances have to be reported, often within a very short period of time. Something like 10 working days is typical. And clearly that in some ways feels like a decent amount of time, but it requires there to be a chain of escalation of information. If someone starts that suddenly doesn't turn up for work, you need to have a system whereby that gets flagged and moved to an appropriate person who can report that. So how does that responsibility work in terms of the system? You have to have an authorising officer, senior individual. In fact, the guidance says the most senior individual responsible for recruitment of staff at all times, and they will be ultimately responsible for the license and ensuring that the organisation complies. You also need a key contact, and they will be the person who receives most of the key information from UKVI around steps they need to take as a sponsor, changes, allocations of new certificates, etc. And level 1 users, and they're very busy normally. Those are the individuals who have day-to-day access to the sponsorship management system, which is on the next bullet point there, the online portal through which you do almost all of your activity as a sponsor. And you must have those in place at all times. And that's an important point, because one of the things we often see is somebody moves out of an organisation, and the risk is that we haven't actually had them log on and ensure that they've replaced themselves, so to speak, with someone else, so that there's always someone in that role. Mention extension and switches there. You're going to need to have a system which lets you know how and when someone's sponsored visa is coming up to expire. So you need to consider there, in advance of that, dialogue with them about whether you're going to sponsor them for an extension or a switch into another category. So you don't want to be left with visas expiring and you only spotting it last minute and it being too late to put in place in an orderly way, certainly a proper transition to an extension or a switch. Lots to think about there, lots that we do in our training sessions there. We cover in our half-day training sessions for new teams to talk about what their respective roles are and what they do. Moving on to the next slide. And I think we're going to break for a couple of questions at this point, because we've had some questions around the system, how it works, understandably, given just over half of you have not been sponsors before.
Hi, Adam. Yeah, we've had a few questions through, so I thought I'd put them to you now. One of them is, does the authorising officer have to be a director of the business? And do they need to be based in the UK?
Okay, yeah. There's two bits there. No, they don't have to be a director in the statutory sense. They simply have to be the most senior and appropriate person responsible for recruitment of staff. So it's typically a senior HR person. And in terms of the UK, yeah, they do have to be permanently based. They have to have the UK as their base. So that is a requirement. And we sometimes see that, don't we, Phil, in terms of setting up sponsors, particularly where you've got, I don't know if anybody on the session today is actually just branching out into the UK, setting up a new branch or operation there in the UK. Needs to be a sponsor fairly early on to bring other people across to the UK. We sometimes find that is an issue we have to get around, which is there needs to be at least one person from the off who is based in the UK and can act as the authorising officer. So you need to get at least one person on the payroll in the UK before you can do this process, and they need to be suitably senior.
I like this question. How easy is it to use the SMS, the sponsor management system? And is the system changing from 2021?
Yeah, I know why you like that one. Yeah, you and I would probably be a lot less busy than we are if it was always easy to use. I think the answer is that organisations do get to grips with it over time, but to be fair, it's not the most intuitive system or one that you would feel is similar to a portal or system you use in other contexts. So there is a bit of a learning curve there. And I think that most of our clients find that they need to use the user manuals quite heavily, and or us to walk through that process. And I've just seen a chat comment there from somebody on the session saying it is user friendly, and then a big not afterwards. So I was hoping they might have some positive experience. So it's just us, but I'm afraid not. So yeah, it's a good question. Essentially, the second part there, I think, Phil, wasn't it, is whether there's changes.
Which, yeah.
Yeah, the answer is, I think it goes to that radically changing the system, what we've been told about, and we've been told it would be simplified and streamlined. Well, as it stands, let's hope something is announced between now and New Year's Eve. I don't think that's very likely. As it stands, no, nothing's changing. But there seems to be an intention that they will streamline it over time. The sooner the better. We don't know quite what form that will take, but I'm sure, for example, if people who have got level 1 user status or or level 2, for example, a slightly lower level of access, could use an app, be able to do some of this stuff much more intuitively. If it pre-populated stuff a bit more, that would be a big help.
And then one more, which I think we can give a more positive answer to, is will the process of sponsoring someone be shorter from 2021?
Yeah, well, certainly all the time that the cap on skilled worker visas is suspended, you haven't got that potential month-on-month applications for, or waiting and getting a request in by the 10th of the month, waiting then for later in the month to see whether you've got a certificate. That all falls away. And we've got the removal of the 28 days advertising process. So in theory, you could save about 8 weeks in a typical process of sponsoring someone, I think. Good. Okay, so quickly then, before we do some further final questions, they're just looking at the cost-benefit analysis, which I think is an important thing for people to be thinking about. In fact, whether you're a sponsor yet or not, because a lot of you, there's a high volume of EU national workers who are currently free moving and frictionless and pretty much no on cost in terms of visas. It's just relocation expenses, isn't it? Who will suddenly be in this category. So I've taken a 3-year visa example here to look at the cost benefit. If you're a medium or large approved sponsor, you're going to pay £1,476 for your application to become that sponsor. That's a 4-year renewable cost. You pay an immigration skills charge, which as a medium or large sponsor is £1,000 for each year. It's a minimum of 1-year cost at 1,000, then it's in 6-month increments, but essentially £1,000 for each year of the visa you're sponsoring. So you've got a £3,000 cost there. You've then got just under £200 cost for the certificate of sponsorship when you actually assign it on the online system to the individual, so they can take that number and apply for their visa. So you've got about just under £5,000 there to think about in terms of the cost, 4.5, yeah, £4,700 odd. Plus, if you're covering the migrants' costs, which just hadn't been a consideration, obviously, currently, other than things like the Eurostar fare to get to the UK. If you're coming from Paris, for example, if you just exclude dependents, so family members of the visa applicant, there's about a £600 application fee. They'll also, unless they're benefiting from the health and care visa exemptions that are going to come in, they'll also have a immigration health surcharge, so a contribution towards the NHS, payable upfront of £400 for each year of the visa. So for a 3-year visa, you're at £1,200. So we're into several thousand, and for a migrant and their family, if you're covering the total cost, you've got additional application fees there, probably more IHS, could be in excess of £12,000. Now there's a broad range here, because if you're a charitable or small sponsor, the application fee is about £1,000 less to become a sponsor. Your immigration skills charge in this scenario would be only about £1,275, something like that, not £3,000, because it's lower if you're a smaller sponsor. And the assignment fee is the same. But you can see that for an individual with no dependents, it could only be a matter of a couple of £1,000, £1,500, etc., if you ignore things like relocation expenses. But the key point here is it may create a new decision-making process or analysis for you to do when you're considering the viability, attractiveness of getting someone from particularly Europe, which is going from pretty much cost-free to on cost, with even if it's suboptimal solution, like, well, we'll find someone who's not perfect for the role but can do most of it, and we'll upskill them, and or we'll have a consultant from abroad backfill the bits they can't do. Definitely something to think about going forward. Just moving on to the next slide. Salary and skills. This gets very complex. It would be probably unhelpful to try to, and impossible to unpick and give you an answer that applies to every scenario that you can just take away and use on this. But you're going to have tradable points about pay and skills. Essentially, pay and skills might be that it's a shortage occupation as well as another route, or that you're a new entrant, meaning you're under a certain age or from a student background, switching. The typical rate for the skilled worker visa is £25,600. It can be lower, it can be £20,480, but it never drops below that. That's a floor in terms of the pay level. And in fact, as a sponsor, you must pay the higher of that general pay threshold, whichever of those which applies, 25,600 or 20,480, say vast majority being the 25,600 category, and the going rate. And that is the rate applicable to the particular role you're sponsoring. So currently we use a thing called Appendix J to the rules, where you have to go down and identify the closest matching SOC, or Standard Occupational Classification code for the role. There'll be an ONS tool, which we'll be sending links to in due course, which has to be used from January. You punch in the job title, it will tell you what the closest SOC code is. You'll then look, and firstly, you'll be looking, thinking, well, is it at least A-level? Or if I'm under intra-company transfer visa territory, you'll be saying graduate, but for skilled worker purposes, is it A-level? And then actually, what's the pay level under the code, not just the general visa threshold, because that can be higher. So in theory, you might find that your SOC code is a certain number, and that means that the minimum pay is actually at 29,500 or 31,000. You've got to pay the minimum. There's an additional requirement to get to that lower pay exemption for new entrants, which is they must be coming not just a certain age or coming out of graduate, etc., but going into a role that they're embarking upon as a career. Going to be some interesting points around the guidance on that, what that really means. And then of complexity around the 70 and 80% requirement. So you can see that the 20,480 is an 80% exemption, dropping to 80% of the typical amount. But there's then also a 70% threshold, which is the percentage of the going rate. So if you're a new entrant, you must be paid at least 70% of the going rate for the role and at least 80% of the general threshold. So there's lots of activity there and work to do to assess pay levels and the circumstances of the individual to identify how that works. I've done an article on it on our website, talks through it in a bit more detail, but we are going to need to get used to this new functionality and do some fairly complex calculations to work out where the pay level really sits. And it's going to be important when you add on those costs compared to what you might try to find from the domestic workforce. Moving forward. So, and to wrap up before we just have a couple of questions, we've only got a few minutes left. Action points. Consider now your need for that demand-driven access. What's it going to be in 2021? Because as we've said, from outside the UK, there's going to be that level playing field of sponsorship requirement for the vast majority of that. If you're a sponsor, are you compliant? What's the impact of the changes in terms of how you're going to run things? Are your key personnel still appropriate? Are they going to get a lot busier and therefore do they need to change? Do you need an update or training on your systems? Do you need an audit? Either do that yourself. When we train, we come and do half-day trainings, we give checklists for self-auditing, or we can look at files and reporting, etc. ourselves. What are you going to need in terms of numbers of certificates? How many people are you going to want to sponsor in 2021? And do you need to ask for that allocation now if you're an existing sponsor? If you're not a sponsor, it's the big question, isn't it, of how and when should you be applying for your approved status? Do you need it now because you think from January, very early in that year, you're going to need to sponsor people? Or do you feel that you can wait? Who will be your key personnel? And how will you need to adapt your systems? Almost always we find, for Phil and I, that there is adaptation that needs to be made, not least around reporting procedures of changes to migrant circumstances that won't currently be in place. And which visa routes will you sponsor? Do you want to get an intra-company transfer route? Now, can you? Do you have foreign entities of common ownership or control? And what would be the benefit of that? So lots to think about before then deciding on any applications you might need to make if you're a new sponsor. There's a process to be done on that. So I think we're going to we'll probably take 2 questions, and we will be doing a questions and answers document afterwards for any that we've missed. And so, yeah, the first one I've got here is what will happen to EU nationals if they don't get settled status, i.e. they only get pre-settled status? Well, I think the answer there is for settled status, or for EU nationals, you get pre-settled status. It gives you a 5-year grant, and that's linked to the 5-year period in the UK through which, if you've stayed in the UK in the right way and not been in breach of conditions, etc., you can then seek permanent leave. If an EU national gets to that 5-year point and doesn't do anything, well, they will have failed to obtain further leave, and I think the position is that they will be here without leave to remain, and therefore not with a lawful basis to stay. A bit like someone who's been here with a tier 2 worker visa, but who just allows it to expire, doesn't get settlement, and overstays. So it's a very bad outcome. And it does mean, I suspect the question is going to, well, you know, how important is it for EU nationals to, and for employers to know that EU nationals are looking at this? It's very important in terms of whether you can still employ the individual and their personal circumstances. The other question I was going to take is, because we are short on time, what are the consequences of, and this is for you, Phil, I think, what are the consequences of a Home Office visit, after June 2021, you mentioned that the EU nationals can get their status and need to get their pre-settled or settled status by then. If a sponsor gets a Home Office visit after that and they find that you've got EU nationals who don't have the status, what's the potential consequences of that?
Thanks, Adam. Yeah, I think, yeah, unfortunately, it's quite likely in that circumstance that the sponsor is going to find their approved status being revoked. I think it's going to be difficult to argue against that, because one of the key things as a sponsor is that you're doing your right to work checks, and that everyone within your organisation has appropriate permission to reside and work in the UK. So if as a sponsor you failed to conduct those checks properly in relation to EU nationals, you haven't found out that they in fact haven't done what they're supposed to do, haven't obtained at least pre-settled if not settled status, then the UKVI is going to take a very dim view of that, and I think it's highly likely to revoke the licence, unfortunately. So it's absolutely critical that sponsors, as well as all other employers of course, but from the sponsorship perspective, ensure that they are checking, and that might have to be an uncomfortable conversation with an individual, but it has to be done.
Yeah, absolutely. And there's a civil penalty risk there in theory if you haven't maintained that excuse because you've not maintained a valid evidence of right to work beyond that point when they needed to get settled status. So that's a very good question. Thank you, whoever gave us that question. I think there was somebody in advance, so forgive me, I can't remember your name now. Just quickly then, before we wrap up, all the slides, a Q&A document and the video are going to be posted next week for viewers to watch and catch up on or revisit. And if you would like a list of our key links to information online, mainly government web pages that sometimes are a little bit difficult to get straight to, so you can cut straight to them around right to work checks, changes that are coming, a whole suite of things, do email our marketing email address on the screen there to request a copy of that. You can also go to our immigration team webpage where we've expanded that to set out some of the key ways that we're supporting employers and organisations on this particular issue, given how important it's going to be over the next 4 or 5 months and beyond. Thank you very much, everybody, for attending today, for your questions. I hope you found it helpful and informative. Thank you, Phil, as well, for your contribution. And we'll see you at another webinar soon, I'm sure.
Thanks very much, everyone.